And so today we're here for a sentencing, and that sentencing, both sides really are in agreement, but I want to just highlight a couple things. The legislature has given the courts 7 goals of really things to think about for sentencing. And of course, the law, we have court cases and court decisions and precedent, but these are the 7. 1, ensure that the punishment for a criminal offense is proportionate to the seriousness of the offense and the offender's criminal history. 2, promote respect for the law by providing punishment which is just. 3, be commensurate with the punishment imposed on others committing similar offenses. 4, protect the public. 5, offer the offender an opportunity to improve himself or herself. 6, make frugal use of the state's resources and local government's resources. And 7, reduce the risk of reoffending by offenders in the community. This particular series of events that occurred are the most serious offenses we have in the state of Washington. Mr. Thunheim touched on this, but the state included as Appendix A in their original sentencing memorandum the legislature's classification of these offenses: aggravated murder in the first degree. It's aggravated murder in the first degree based upon the way that terminology is defined in RCW 1095-020, which is a definitional statute, and then 10.95.030 is the sentences for aggravated first-degree murder. The legislature has scaled all of the offenses between levels 1 through 15, except for aggravated murder in the first degree, which is a level 16 offense. The mandatory sentence is life without the possibility of parole, and that's exactly what the court's going to impose on Mr. Burke. They will be consecutive sentences, count 1 and count 3. I'm trying to explain just so if people have questions. Count 2 and count 4 were lesser degrees of murder that gave the jury basically options in terms of what findings they would make. The jury found proof beyond a reasonable doubt for all counts. But because count 1 and count 3 are the aggravated murder in the first degree, they control, and counts 2 and 4 are less important because those are lesser degrees of murder. And so that's why everyone was focused on count 1 and 3. But count 1 and 3 will be life without the possibility of parole. Those will be consecutive sentences. I appreciated Mr. Thunheim being thoughtful about community custody. Community custody in this circumstance seems unnecessary because it's a life sentence without the possibility of parole, and that is the court sentence. But I appreciate the carefulness of saying it should be included because by statute it is something that, because of the serious nature of murder, that will be ordered as well. When the court, and I just want to address the defense objection, I appreciated Ms. Norden's briefing and her oral argument. I appreciate that defense is making this objection, but also the acknowledgement that the law does not support the request, which is why defense wants to raise the objection. But the law is clear. I want to go a step further, though. When the court looks at the goals that I read into the record, these goals of what a sentencing should be, in this case, this is the most serious case that the court has. And this sentence of life without the possibility of parole is the just, appropriate sentence when the court goes through and considers all of those factors, when the court had the ability to listen to the same evidence the jury did and to consider this case in the light of my going on close to 30 years experience in the court process. This is an appropriate and just sentence in this case, and the court will order it. The court is also ordering the restitution that'll be reserved in terms of the amount, but the court's ordering restitution. That means that within 6 months of today, a sentencing amount has to be submitted. Defense will have an opportunity to review that, to make any pleadings they want for the court to address. But if the state wants to pursue restitution, it just has to make sure the court has the ability to rule on that within the next 180 days. The court is ordering no contact with Karen and DeVito's family. The court is ordering no contact with all of the individuals that testified at trial, with the exception of Mr. Burke's daughter. It might be, and we heard testimony from her, that there have been orders that she has obtained throughout their history, but that's not really part of this case. And the court's not ordering any no contact between Mr. Burke and his daughter as a condition of the sentence in this case. The court's also not ordering anything that would prevent Mr. Burke from speaking with the defense expert in this case. The court is urging Mr. Burke to get involved in every bit of social programming that you can get involved in at the Department of Corrections, everything that's positive. You know, one of the things the court heard, and you might be aware, is that there used to be a death penalty in the state of Washington that stopped. So you have a gift that Karen and DeVito do not have. You have a gift of life. And so what I strongly encourage you to do is to get involved in everything you can that is positive, to try to undo, even if it can only be in a small amount, undo the huge harm that you've caused and the huge hole that you've caused in this community based upon your actions. The court is ordering that Mr. Burke will comply with all conditions imposed by the Department of Corrections, that of course he'll maintain law-abiding behavior, that he will engage in all positive social programming, including mental health treatment, while he's at the Department of Corrections. I'm really sorry that everyone is here under these circumstances. The courts obviously are limited. I can't undo the harm that was done. But my experience has been that sometimes having a sentencing, having an opportunity to have at least legal closure to a case, can bring some peace. And I hope that having this opportunity and the opportunity to be through this process and see it to conclusion and to hear what the sentence is does bring some peace and allows grieving to continue, which I know will continue for a long time, probably forever in some ways. But what I would ask all of you is, and I think you all did a really nice job of expressing this either in court or in the letters, is using Karen and DeVito as an example into thinking about how they would want you to move forward and what things they would want you to do. It's clear they would want you to live life to its fullest. They would not want the horrible nature of this crime to impact your faith in humanity, to impact your faith in others. And so I would just encourage you that they sound, and I wish I had had the opportunity to know them, but I've gotten to know them a little bit through all of you. And I feel the richer for even that,